Welcome to another episode of Check Me Out. And this is a really valuable one if you are starting out in your product business. We have Rachel from ARC Legal, and she is going to talk about all things trademark and copyright. And this is a really important one because a number of times when I have new brands come on to work with me, they get all excited about the branding. They've got a cool name, they're ready to go, they do their packaging, and lo and behold, something comes up, say from Australia or even from New Zealand, and someone says, hang on a second, I'm already using that name and I've got prior use. And then you have to go through and redo everything again, which can be costly. And as Rachel and I were just talking about before we jumped on, it can suck up all the profit out of an already, squeezed cash flow business. So Rachel, thank you so much for joining us.
Great to be here. Thank you.
Okay, so let's start from the beginning. Tell us a little bit about what is a trademark. What's the difference between trademark and copyright?
Sure. And I should say first, there's no shame in using the wrong term. Lots of people don't know. So never be scared of using the wrong term. Lots of people think IP is really complicated. I guess it can be, but yeah, there's lots of information out there. I've got lots of free information on my website as well, including what are the different terms. So yeah, don't be ashamed if you use the wrong term, but it's nice to know. So a trademark is, I guess the clue is in the name. It's your mark, your way of making your mark in trade. So it's anything that distinguishes your business from other people. Most often it's your name, so it's how people come and find you. So if they're searching Creative Jam, they know they're going to find the fabulous Laura. But it can also be your logo. So if you think, for example, if anybody else is dealing with school holidays, if you think of the Golden Arches, if you see that logo, you know it's them without even seeing the name McDonald's. And if you don't want to go that way, you need to distract the kids. So a logo can be a trademark as well. You know it's that business. You know it's not BP, for example. And on that note, colours can be trademarks. So if you saw a big green and yellow in a gas station, you'd know it was BP, not Caltex. So you can brand a color, you can brand a shape. If you think of a Porsche, for example, you don't need to see the logo on the back to know, is it the 911? No, what was it? What is that famous Porsche shape? Probably isn't 911. But yeah, if you see that shape, you know that it's that business's brand. So shapes, colors, most commonly logos or words, those can all be trademarks. So trademarks can also be protected by copyright. So copyright protects certain original works, and they include artistic works, which may be a logo. They include written works, which may be a trademark if it's long enough. Musical works, dramatic works, and things like that. So the difference between copyright and trademark, or one of the differences, copyright just exists automatically in any original work you create, in the sense that you haven't copied it from someone else. It's your own independent creation. You can and should put the wee C symbol next to it, your name and the year you created it. You'll still have, if copyright exists, you'll have it even without that warning. I compare it to having a beware of the dog sign. Just because you don't have a beware of the dog sign doesn't mean you have a dog, don't have a dog. So same with copyright. It's good to put people on notice because it makes people hesitate before they rock on and trespass on your property. But it exists automatically if it's your own independent creation. It's also an international right. So if you create a beautiful, or it doesn't even have to be beautiful, an original work in New Zealand, any member country who's a member of the Berne Convention, and that's Berne as in Switzerland, not as in hot things, any member country, which in most countries that would be interested in trading with, have to respect your copyright in that country too. So it's pretty cool and really powerful, especially in this online era. So with trademarks, in contrast, you can have unregistered. Gosh, I'm going on a tangent. I'm telling you everything.
No, it's great. No, it's totally fine. It's absolutely fine.
Luckily, you're recording, so people can play me back slowly because I know I speak fast, but you get your money's worth with me. So with trademarks, in contrast, you can have registered or unregistered rights. And so a registered trademark is an awesomely powerful thing because you don't have to prove your rights. You can just show you've got a registration for that mark in the relevant country. If you don't have a registration in the relevant country and for the relevant goods or services, then you'd have to show that you've got sufficient reputation in the mark and you've used it before someone else, and that deception or confusion is likely. Then you might have rights under the relevant country's consumer protection legislation. So, for example, New Zealand, it's the Fair Trading Act, which most people would have heard of, or passing off. So trademark registration, great. It's like having the papers for your car that show you own it versus having to show that because this person liked you, they loaned the car and they gave it to you. You know, not having a registration leads to the fluffiness in lawyers and having to prove your rights. And the same with copyright in lots of sense. Copyright's great because it's automatic and free and it's nice. But equally, if you don't have a registration, you've actually got to prove your rights. So anything that's ambiguous, read disputes and fights. Whereas if you've got if you can get a trademark registration, it makes it nice and clear. You can actually show you've got the piece of paper showing that you own that exclusive right to use that IP.
I see. So that basically means that if I was to draw a really nice, amazing sketch that was to go onto packaging, and then a client said, "Oh, I want to use this elsewhere. Do you think I should get it copyrighted?" I could automatically say to them, "Yes, absolutely," because it is an original artwork. But say if they wanted to, say their business was called, I don't know, banana pants. That would be obviously something that they could not then say, well, we can't copyright that because the word banana is obviously something that everybody knows. That would be the instance that they would say, okay, I need you to go and have a look if you can trademark that. And if they were able to register that in their chosen field, that would mean that they would be able to get the little TM that sits above the name. Is that correct?
So going back to the start of that, with that beautiful image on the packaging, yes, copyright automatically, but also if that packaging is going to be part of their recognizable brand, I would trademark it as well.
I see.
So I would layer over the copyright with the trademark protection. If they don't have the budget for the trademark registration right now, I'd make sure they put the C symbol and put people on notice, but also make it part of their strategy that they register that as a trademark as well. If people are going to see that packaging without the name from a distance, if you think like a Louis Vuitton bag or something like that, if they're going to see that and think of them, then I'd trademark it as well as soon as they can afford it. I'm thinking of that Friends episode where Phoebe changes her name to Banana Hammock, but Banana Pants. I don't know if you ever watched Friends, but Banana Pants. So from a word trademark and a logo perspective, it's really important to check, as you say, as a very first step, check that no one else is already using that same or similar word, logo, color, etc., for similar goods or services. So it doesn't matter if somebody's using the name Banana Pants for phones. If you're going to be using the name Banana Pants for, I'm trying to think of something relevant on my desk, for
Coffee.
or coffee or lipstick.
Yeah.
No one's going to think, oh, cool, this phone company's now starting to take into makeup. And it was you say, or coffee. Oh, thank you. So 3 different people could have the same brand for makeup, for coffee, and for phones, because no one's going to get confused. There's such different fields. And so if you do find somebody saying that's using the same mark, but it's for a sufficiently different good or service that people are unlikely to make the jump across to you, then you should be okay.
Yes.
And that leads you to the next thing. When you then file the application, you need to be really careful what you file. And that's where I see common mistakes as well in 2 areas. One is that people don't claim the right goods or services when they're filing, because there's 45 different classes of goods you can choose from. Each class has a fee, so you don't want to spend too much on all the government fees. But if you just, for example, maybe you just did coffee cups, but then you didn't do coffee as well. So then somebody could use the mark for coffee and you've actually gone into the wrong class. Or I had one person who did like a personal organising service, and she filed in relation to class 16 for personal organisers, but those are actually the notebooks and the books, not actually the organising service itself. So sometimes you're throwing away money filing and doing it wrong anyway. And another common mistake is people might file for a combination mark, and they'll file for the word and a logo and lots of other material in the mark. And if you file for too many things in a mark, then it actually dilutes your rights for the different elements. So it's much better to, if you can, file at least 2 marks, one for your word and one for your logo, so you've got separate rights in both.
Okay. Yeah. Oh, that's great. I think, there's a lot of really good information in there. So if I take an example of a client in the past, I had a client who had a business that was a woman entrepreneurial magazine. And her logo was red, and it was a woman entrepreneurial magazine in New Zealand.
Yeah.
There was a brand in the US called Entrepreneurial, that's a terrible word, magazine. And
Yeah.
they were also using a very, very similar red. I'm talking maybe 10% different in the red. And they found out about her name and her magazine and ordered her with a cease and desist. So, how can you tell us a little bit about how they were able to do that and why she then had to go and change that? Obviously, there's something to do with the color and the fact that they already had prior use to using the word entrepreneurial, and they could prove it.
Yeah. So, I mean, it's an interesting question. How could they? I mean, you can tell I like analogies. I mean, just because you're going through the light when it's green doesn't mean somebody's going to not crash into you. And same with these people. Just because they're in the wrong doesn't mean that they won't still smash into you and make improper claims. So cease and desist letters, they're incredibly scary to get, and I fully recognize that. But sometimes they've got no legs to stand on. They're just throwing their weights around. So if that US company, they would have to prove to stop someone in New Zealand using a brand, they would have to prove that they either have a trademark registration for a mark that is so confusingly similar that people would be confused. In relation to similar goods or services before your client. If they had that, then I would strongly recommend your client rebrand. If, however, they didn't have a trademark registration, they would then have to show, and it's quite a high threshold to reach, they would have to show that in New Zealand consumer, the average New Zealand consumer would see your client's brand and actually get misled or deceived or confused into thinking it was endorsed or affiliated with that other brand. So that's quite hard generally for overseas companies to prove. It's got a lot easier these days with social media and everything being online, but they'd actually have to take your client to court and actually prove that level of confusion, which is quite a high threshold. That said, the word entrepreneur, the danger of choosing a brand which is pretty descriptive and doesn't stand out from other people in the field is you're going to have a lot of noise in that field. So I'm not a pushover by any means, but equally, if it were my client and that was happening to them, I'd be saying, actually, you can probably defend it. If they don't have any reputation in New Zealand, red is a common color in relation to entrepreneurs, for example. I don't know if it is. If red's a common color, the word entrepreneur is pretty descriptive. I'd say they don't have a strong case. However, if that word is pretty descriptive in the field, once you start searching, you're probably going to find, quite a few other people using similar words and colors. Even from a branding perspective, how hard is it to play whack-a-mole to stop all these different people using similar brands? And what if their product is dodgy? It's not so worrisome in relation to, I guess, media, but what if you're in a baking field and somebody gives somebody food poisoning, or cosmetics and skin falls off? So I would actually say sometimes these kind of warning shots are a good chance to actually rebrand. But normally I'd push back and say, well, no, we've been using this brand. You don't have any rights here. If you really want us to change, we can, but you need to put money towards our rebrand. So I'd actually I'd flip it around and say, look, if you're really that worried, yes, we will rebrand. We don't think we need to, but if you want to put some money towards it and use it as an opportunity to choose a stronger brand.
That's really cool. And basically, in a nutshell, what we're saying is if you do get a cease and desist letter from somebody, it's best to seek really good advice. Get yourself a trademarking lawyer like yourself and get somebody on board to help you with it, because these letters, like you say, when people get these letters or things like that, particularly if they're from a client who really wants to hold on to that position, get yourself some legal advice and take it as an opportunity to look and see, is this actually the right brand name for me, or is this an opportunity for me to grow and find my own special place in the market?
Yeah. And the car crash analogy is like, you just never admit fault. Because just because somebody makes claims against you, take a breath, step back and say, actually, is this my fault? Is it something I want to fight? Because costs lots of money to have disputes as well. Do you need that energy in your life, or actually is this a warning shot saying, actually, I need to choose a different brand anyway? Not because you're being forced to, but yeah. I don't do litigation. I don't enjoy the energy in my life. So I would refer litigious matters to someone else who's amazing in that field. I prefer the creative end, like you do.
Nice. Yeah, me too.
I prefer the education side of thing. Yeah.
And now we, in amongst that conversation, we mentioned countries. So if someone is starting right out from the beginning, there are different markets that you can trademark in for New Zealand and Australia. And say you've got this amazing product, and in the beginning you're like, oh, I think I'm only going to concentrate on New Zealand and Australia. But then maybe in a couple of years you might go, oh, maybe my product would suit the US. What are the important things? When should somebody look at the markets, the different markets that they can go into? And I guess, a little bit of information about the different markets that people can go into, and when would be a good time to sort of consider where you're going to go with regards to trademarking.
Sure. So from a strategic point of view, yes, it's normally best to start in New Zealand, not least because it's the cheapest country in the world to register your brand. So it's a great platform from which to then launch into other countries. So right at the start, yes, I'd file in New Zealand. It starts at $70 for 10 years worth of registration. So it's not expensive. There are no excuses not to register your brand in New Zealand, basically. If you want some homework, one thing you should do is register your brand in New Zealand. Even when a trademark's not registered, you can still use that TM symbol, which you mentioned before, but I forgot to touch on that. So you can use that TM symbol anywhere in the world. It just means you think it's your trademark. It doesn't mean it's registered. It's the R in a circle that means it's registered.
Right.
But most people think TM means it's registered. So why wouldn't you put it on? It goes back to that beware of the dog analogy. A TM means potentially you've only got a chocolate Labrador. So you're not lying. You've still got a dog, but it maybe it's not quite as good at defending your house. Put a TM on now, apply for registration in New Zealand strategically. If you're looking at other countries, including Australia, US, for example, if you file within 6 months of your New Zealand application, you can actually claim protection back to your New Zealand filing date, which is a really great way of staggering your costs. So say New Zealand or Australia in the first year, you'd file in New Zealand now, file in Australia within 6 months. And if anybody is filed within that 6-month period, you'll actually be able to kick them off the register because you can claim protection back to your New Zealand filing date. Is that making sense? Yeah.
Yes.
So New Zealand, Australia. And then when you go overseas, I'd use a thing called, if you just go in one country, you'd file directly, but you're going to need to use a local agent to file. You need, local address for service. If you're doing more than 2 countries, I'd file via what's called the international or Madrid system, which lets you use your New Zealand application as a base and then designate all the countries where you want to protect your mark. So it keeps your costs way down. It means you can file it all via New Zealand into the World Intellectual Property Office. You don't need local agent fees unless you get an objection. And if you change your address, you only have to change your address in one place versus paying all the fees in all the different countries to update all the details. So it's a really good way of managing your brand once you go global.
Oh, and what is the trademarking process? I've got this brand, say, let's go with banana pants, because I don't know why. I just saw pants and then I saw yellow and I was like, well, that'll do.
Nice.
Okay, so I've got this brand. It's called Banana Pants. I've done my due diligence. That's a terrible word again. And looking at, because there are other things, just as a side note, a little asterisk in this, there are other things which you should also do with looking at trademarking, and that is whether the name is taken as a domain name, whether it's taken on social media, and whether it's taken via the New Zealand Companies Office. So these are all the things that you should tick box along with trademarking your name. So I've done all those things and everything, and I'm going to come to you and say, right, I have got a coffee brand and it's called Banana Pants, and I'm ready to go ahead and get that registered. Help me, Rachel, what can I do?
Sure. And so, the process I go through is I've come up with an acronym called STORM. I don't know why, but I need a better word, but the letters work. So the first one is the spotting side of things, which you've mentioned, working out what else is out there, making sure there's no clash. The next one is tracking. First one is spotting what IP might be in it. What are the trademarks? Is there a word and a logo, or just a word? Is there any copyright? Potentially other forms of IP like registered designs and patents. So spotting all the different IP that might be there. The next step is tracking, and that's the check which you were talking about. Tracking and seeing what else is out there, making sure there's no conflict. The next step is making sure you own it. Like you mentioned, coming up with a beautiful design on the packaging. Make sure you've actually had any copyright assigned to you. So any IP in your business, it actually is owned by you. What if an employee came up with it in their own time and then they want to go and use it elsewhere? Or you've got a third party to manufacture something for you and they want to use that mold elsewhere, and it's part of your recognizable brand. So make sure you own all the IP and then record it. So there's 3 steps before you even get to, jumping on icons or wherever you go and registering your IP. Make sure you do those 3 steps first, and I can help with those. And then it's the registration, and that's when the filing strategy comes in, and working out what to file, what's your budget, is it just the word at this stage, is it the word and logo, is it just New Zealand, is it just for the makeup, or is it just for the coffee, or is it for the coffee cups? Working out where you want to go in your business. So from a strategic point of view, what does your budget, how can you get your best bang for your buck? And then it's the monetization side of things. If you want to let other people use your brand, you can license it. You can do franchises, or if you register your mark for coffee cups and coffee and you don't actually use it for coffee cups, why not sell your brand for those products to somebody else, make some money and reinvest it? So those are the 5 steps I generally help with along the way. I've put some tools on my website, some free downloads, how to capture your IP along the process. And there's also a download on there on how to do the trademark check, to make checking domain names, checking social media, checking company's office, to see what else is out there to make before you launch. But yeah, the check is just one step and the registration is just one step. You've also got to see, you've got to think laterally, like, what else do I have, and do I even own it? And how can I monetize it as well? I mean, maybe don't sit and ring fence it. How can you actually commercialize it? And it's not just about making money. I mean, if you want to actually freely share your IP, and I'm all about that. If you own your IP, then you've got much better control, a much better ability to actually let people use it, versus if you just put it up there without ring fencing it, then lots of people will just steal it. So making sure you take all those clear steps means you're actually able to better control how your IP is used and make sure it's used in the way that you want it to be.
Yeah. Oh, that's wonderful. Yeah. And again, it just proves, this is why we have trademarking lawyers, because just like, buying a house and dealing with conveyancing, it's quite confusing and there is a lot to it. But there is a lot to it for a reason. And all of these things that you've spoken about, like the scary cease and desist letters, the different markets and things like that. And also the fact that there is so much more to it. Like, you've just gone through a whole bunch of things that you can actually do with your IP, with your brand, other than just registering it. And one important question I think I have is it absolutely compulsory and necessary for a brand to be completely trademarked and locked up, to have that beware of the dog sign, to go into retail?
So if I were going to spend my money on anything, it would be more to, oh yes, I'm risk averse, bloody lawyers. I did a post last week, which I haven't put up yet, is what can you do for free? If I was going into retail, at the very, very least, I would check that I'm not going to have to rebrand before I even get started. So is it essential to have it locked up? Well, it depends if you can afford to rebrand again. Because if you don't have a trademark registration and you launch your business into retail or wherever, if somebody else thinks that's an awesome brand, I love it, and they start using it, you're in that fluffy stage where actually you'll have to prove that you are using it first and take them to court to stop them. Versus if you have a trademark registration, somebody thinks that's a cool name, they jump on similar social media handles and domain names. If you then go to Facebook or Instagram or the domain name provider and show that you've got their registered rights, that provider will kick them off because you're in clear breach of their rights. They won't get involved if you're trying to say, no, I was using it first, I've got similar rights. They're like, well, we don't enter into disputes. It's over to you guys. So
yeah. And then I think what we're saying here is the cost. I mean, knowing my side of the business and just the creative side of things, the cost of rebrand is way up here versus the cost of trademarking. So it's really a no-brainer. There has been actually, just as an example of a story that I had seen last year in a brand, there was a lovely girl who was using a phrase for her business and her business name. It was good. She had been going for a couple of years. She started dealing with a bigger company. They took that name right out from underneath her and registered it and trademarked it, locked it down, and she could do nothing. And as sad as that absolutely is, she's got another great name now and she's doing just as well, if not better. But it just shows you that a lot of people, when they come and try to register a trademark or a brand, what they're mainly thinking is on people attacking them and saying, hey, you can't use it. But actually, the side that we also need to think about is you creating this amazing business and people coming and using it from you. So that's, I think a lot of people don't think about that. They're more concerned or more scared about it being people having prior use of that.
Yeah, exactly. And they're equally important. So yeah, I think maybe in the past, I mean, I've been doing this for 20 years. So maybe when we first started, the check was even more important than the registration because markets were very, geographically located. Like you could have the same company in Christchurch and Melbourne and people wouldn't get as confused because it was dependent on people traveling back and forth to get confused. Whereas now we're all online. When I first started the internet, I'm that old, the internet was just coming around, so it wasn't as big a thing. Whereas these days your trademark could reach people easily, obviously, around New Zealand and around the world. So you've got to be, it's much more important that you not only check, but you also register if you want to use your mark in your market of interest.
Awesome. Oh, thank you so much, Rachel. Is there anything else or any other little tips that you would like to give people? Obviously, you've been awesome. No, it's been really good because I think a lot of people don't think about this stuff. Your focus when you're starting, particularly when a FMCG brand, is getting the product right, getting the brand right, getting the pitch to retail right. But all of that stuff doesn't matter if you haven't done your checks or your due diligence, which I'm just not even going to try and get that word right, on actually seeing whether anyone else is out there. And to a large degree, when I work with brands, I will always say, hey, have you thought about trademarking this? Have you done that work? And say to them, before you come to me, go and do that. Go and see Rachel. Go and do that bit first, because it is really important to actually do that.
Yeah, and I do have a free worksheet on how to do a check yourself. I mean, my analogy with DIY, I mean, I'd rather people did something. Like my husband's a plumber by trade, so I could probably install a toilet, having seen him do it a few times, but you don't know what you've done wrong until it's too late. So me and my analogy, sorry. I mean, use the worksheet so at least you have an idea. You might see something obvious come up that you don't even need to spend time and money with a lawyer if you can see a trademark which will clearly block you from using it. So I'll share that worksheet with you later.
Awesome. So we'll put the link to that on the YouTube and on LinkedIn as well. So cool.
I think, it's
amazing. Yeah. Thank you so much, Rachel, from ARC Legal, for joining us. And we shall talk to you soon.